Hi, I'm Eric Hall, Chairman of the Equal Voting Rights Institute. In America, equal protection has been a core constitutional principle since the Civil War. The 14th Amendment says, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor deny to any person within its jurisdiction the equal protection of the laws." But back in the bad old days of Jim Crow, that was just on paper. States and local governments playing racial politics rigged elections to make sure that minorities could not fairly participate and could never elect their preferred candidate to any level of office. The Civil Rights Movement demanded better. Brave Americans of all races and creeds put their lives on the line, suffering attack, arrest, and sometimes murder to make equal protection a reality rather than just a slogan. Congressman John Lewis, Hero Selma, explained, "It is an affront to all of what the Civil Rights Movement stood for, what people died for, what people bled for. Those of us who marched across that bridge 51 years ago, we didn't march for some racial entitlement. We wanted to open up the political process and let all the people come in, and it didn't matter whether they were black or white, Latino, Asian American, or Native American." In 1965, in a triumph of American principles over American practice, Congress passed the Voting Rights Act. No one would be denied the right to participate because of race. In the years since, the courts took this guarantee as a mandate to require the drawing of voting districts where minorities get to pick their own office holders. To prevent state and local governments from rigging elections, the courts, ironically, require maps that rig elections, but that's settled law. How did that even happen? States and local governments, barred from outright blocking minorities from registering and voting, used their map drawing power to assure that, even when they voted, those minorities' votes were swamped by the majority in each district. They do that by slicing and dicing the minority between districts. You're 45% of the electorate? Congrats. You get to elect one member to a 10-member board. The court said no, and found this to be just as illegal as outright blocking voter registration. So courts required the drawing of performing districts, where minorities could elect who they liked, in numbers roughly proportional to their share of the population. Then America changed. Modern demographics aren't what they were in 1965. We now live in a more diverse society. Equal protection, that is the whole point of the Civil Rights Movement, says that it doesn't matter who's on the short end of the stick. State and local governments can't dilute anyone's vote by slicing and dicing an out-of-favor minority group between districts. So if there were a locality where a 48% racial minority only gets to elect 1 in 4 officials, that's a problem, no matter what race that is. That's our case, Harding versus County of Dallas. Dallas gets described as a majority-minority jurisdiction. It has a small but persistent racially defined electoral majority. Our plaintiffs have argued that the local racial minority, which is Anglo, is just under half the electorate, but has been carved up between districts to only allow it to elect one of the 4 single-member district seats on the County Commissioner's Court. Dallas County's response? They refuse to produce witnesses, arguing that a case brought by white plaintiffs does not rise to serious litigation. They argue that the Voting Rights Act offers no protection to a racial minority unless today's racism follows on the heels of a past history of pervasive discrimination. This would mean that as long as a majority alternates who is frozen out every decade, racial gerrymanders would be just fine. It's time for something better. It's time to live up to the promises made by Lyndon Johnson and Dr. Martin Luther King and the Reconstruction generation of the 14th Amendment. But we need your help to achieve it.